All right, the final case to come before the court for argument today is Karvo Companies, Inc. versus Ohio Department of Transportation. Each party will have 15 minutes to present its arguments. Appellant may reserve up to 5 minutes for rebuttal. Counsel, when you take the podium, if you want to reserve time, let me know how much, and I'll do my very best to keep you apprised of the time. The arguments are being visually and audibly recorded to be posted online, so please keep your voices up and remain behind the podium. We've read your briefs, and we are ready to begin when you are.
May it please the court, my name is William Cole. I'm with the Ohio Attorney General's Office, and I represent the Department of Transportation. I'd like to reserve 2 minutes for rebuttal. Your Honors, construction companies like Karvo that bid on ODOT projects have no right to receive a contract award. A certificate of qualification is not a license because it confers no right on the contractor. Pre-qualification applies to ODOT. It limits what bids ODOT can accept and what contract awards ODOT can make. Because a certificate of qualification is not a license, then any adjudication on the certificate necessarily must be an other adjudication under 119.12b that can be appealed only to Franklin County. Since the court below did not have jurisdiction over Karvo's appeal, that decision must be vacated. Although Section 119.01b defines license to include any certificate issued by an agency, there's something it's not that simple. Otherwise, any document with the word certificate, any certificate issued by an agency, regardless of what it says or does, would be construed as a license, and that is not a fair and reasonable application and construction of that statute. The key is...
Counsel?
Yes, Your Honor.
Is it not fair and reasonable because it, or lack of a better way of saying this, because it doesn't go your way, or because it contradicts other portions of other statutes?
Well, it's whether it goes our way or not, I'm being a good advocate.
We'll take that as a given.
I appreciate that, Judge Callahan. So it's not reasonable because there are, I can cite a couple examples of certificates that I don't think anyone would reasonably say are licenses. The agencies issue certificates of completion for training and education. They do not confer a right. Technically, they have the word certificate, but they're not in a reasonable sense. You wouldn't consider it a license. There are
the certificate at issue in this case confer a right to bid on projects.
It does authorize the bidder to submit bids, but the operation of the statutory scheme limits ODOT. It's not illegal for Karvo when its pre-qualification was revoked, or for a non-qualified bidder to submit a bid. Now, they're not going to get the contract, and there are some exceptions that are set forth in the statute. But the statutes all limit what ODOT can do. They said ODOT 552501, while the director can reject all bids, the ODOT director must award the contract to a pre-qualified bidder. Again, that language is directed to the power of the agency, in this case ODOT. 552502, if the director attempts to award a contract to a non-pre-qualified bidder, the award shall be void. 552508, the ODOT director may not consider a bid, subject to the exceptions, is not permitted to consider such bids. So while the end result may be that the bidder cannot get the contract award, the operation of the statutory scheme in Chapter 5525 acts as a limitation on ODOT. And that's really what distinguishes this case from total office products, the type of certificate. That was a minority business enterprise certificate under the DAS statutes, 125.081A. And the key difference between that type of certificate and the certificate of qualification is that the 10th District made clear that it would be illegal for the state, or rather for the bidder, to participate in set-aside bidding without that certificate. In fact, it would be a crime to do so. That is not the case here. There is no conferring of a right. And in fact, Karvo's brief, which says that total office products is not distinguishable, they say, and I quote, because it would be illegal for ODOT to award a contract without a certificate of qualification. That's a correct statement. It would be illegal for ODOT. Again, the statutory scheme is a limitation on the department. It is not total office products involves conferring a right on the bidder. The bidder cannot participate without the certificate. Here, bidders can submit, in fact, they submit all the time. It's not in the record, but ODOT gets bids from non-pre-qualified bidders. ODOT is prohibited from awarding contracts, but that's a step removed. The operation of the statute should determine what jurisdiction applies, how that statute operates, how that scheme operates. The 119.12A1, which allows a bidder or a party to appeal to its home county, is based on the party. It's based on the applicant. The Franklin County provision for jurisdiction 119.12B is based on the government, where the seat of government is. And that makes sense here. That's what, because the limitations in 5525 on ODOT's power, on its decision-making process, apply what ODOT is, the seat of ODOT is in Franklin County. Karvo and bidders do not need a certificate of qualification to operate or do construction work. They don't need it to do subcontract work for ODOT, at least up to $800,000 per calendar year. And they don't even need it to submit a bid. It is not illegal, but it is illegal for ODOT to attempt to award a contract. Again, that doesn't relate to, that is the end result, but it does not relate to the operation of the statute. Essentially, pre-qualification gets a bidder on ODOT's list, and that's supported by 5525.05, which the director can post who's on the list. That's essentially what pre-qualification comes down to, being on a list. It's not that Karvo or a bidder gets more rights than they had before. The statute operates as a limit on the department, and therefore jurisdiction under the Administrative Procedure Act 119.12 dictates that any appeal has to go and only go to Franklin County. That's what the ODOT notice said, and Karvo appealed to both courts. It appealed both to Summit County and to Franklin County. Now they put some disclaimers on their appeal to Franklin County saying, we really don't think we need to be here, but we're going to play it safe, and maybe not a bad move on their part. And we contested the jurisdiction. The lower court disagreed, and at that point Karvo dismissed its Franklin County appeal. That was an error. That is reversible error by the common pleas court. But even if this court believes that the lower court did have jurisdiction, it should still vacate the decision, because ODOT, if the court finds that Summit County, not Franklin County, had jurisdiction, then ODOT, it didn't just get it wrong in the order. It was not a final appealable order under the Hughes decision, the Supreme Court decision in Hughes, which says for an agency order to be final and appealable, it must strictly comply with 119.09's procedural requirements. The method of certification, which is not an issue here, but the advising the party how to perfect their appeal. Well, if Summit County is the proper court, then telling them, again, we believe ODOT at all times, we believe then and now that the jurisdiction was in Franklin County, but if you disagree, then the notice doesn't comply with 119.09, and it is not a final appealable order. Now, Karvo says because ODOT did not raise a Hughes defense at the common pleas level, that is waived, and by implication they go further and suggest that this court would have would have to turn a blind eye to subject matter jurisdiction, which is contrary to decades of case law that courts are, not only this court, but the common police court are responsible for policing their own subject matter jurisdiction. They rely on the Colonial Village case. That was not a 11912 case. It was a tax case decided on its particular circumstances. The Supreme Court went out of its way to say this does not affect those line of cases, including sun refining, which is largely what Hughes is based on, that hold that the filing or the order requirements are mandatory and jurisdictional. But probably out of the 8 reasons we gave you in our brief why Colonial Village doesn't apply, the most compelling, besides the fact that it's not a final order, why there's no waiver here, is because ODOT never submitted itself to the jurisdiction of the Summit County Common Police Court. We've moved to dismiss it. Now, we did not include a Hughes argument. Frankly, we just never, it really didn't cross our mind. We believe this was a Franklin County Appeal 11912B case. That was the order. We defended that. Okay, the Common Police Court disagreed. But we moved to dismiss that. We noted that that Karvo had a pending appeal in Franklin County. The Common Police Court disagreed. All right, we appealed from that. But we certainly did not submit ourselves to the jurisdiction of the court. The Colonial Village also involved a method of certification. That's not an issue here. The limitation on jurisdiction here fully applies. Again, even if this court, either way, whether you think, if it's Franklin County, absolutely, you should vacate. That decision would go away and the ODOT order would stand. But even if you believe that Summit County had jurisdiction, based on Hughes, ODOT's order would not be final and appealable. And therefore, a vacating of that decision, plus a remand to ODOT, or perhaps to the Common Police Court to remand to ODOT, to issue a compliant order, would be the proper procedure here. Then Karvo could appeal pursuant to 11912. Then time limit would start at that point. Might not be the most efficient, but jurisdictional statutes sometimes operate that. Sometimes they operate that way. And rather than take what the 10th District has done in the Brass Poll and some of the other cases to say, well, it's really unfair, so anytime you don't raise a Hughes argument at Common Pleas, it's waived, and the Court of Appeals has to overlook that. If there's some inequity in the law, then the legislature perhaps should change that. But the Supreme Court has said that the requirements, the order requirements of an agency pursuant to 119 are mandatory and jurisdictional, and subject matter jurisdiction cannot be waived. For these reasons, Your Honor, unless there are any further questions, because the certificate of qualification does not confer a right on the bidder, but the total office products the NBE does, this court should vacate the decision below. Thank you.
Good afternoon. May it please the court, counsel, I am Judge Sheaf and I'm here today on behalf of Karvo Companies. I'd like to begin by thanking the court for moving this date so the Karvo family could be here for the hearing. It's very important to them. I understand that you've read the briefs, so I'll try not to be redundant of myself, but I believe what's happening here is the Department of Transportation wants you to determine when the words any certificate do not mean certificate, or when an agency is not an agency. I respectfully suggest that, in view of the argument that we've read and just heard, that the department's problem is with the legislature and not with the decision below. If, for all the reasons that we've just heard, the more appropriate vehicle for appealing a decision to revoke a bidding qualification certificate is the Franklin County Common Police Court, then I think ODOT should go to the Ohio legislature and have that change made, because I learned a long time ago from a judge that when in doubt, go to the instructions, and the instructions here are pretty clear. The legislature has spoken pretty clear. Revised Code Chapter 119.12A1 says the revoking or suspending of any license may be brought in the home county of the person who is affected by that. There is no dispute below or here that Karvo Companies is a resident of Summit County. So what is a license? Chapter 119.01B defines license as any, and you can go delete license, anything else, to the word certificate, issued by any agency. There's no footnote to the word certificate. There's no asterisk to the word certificate. There's no case law beneath the word certificate that says, but we meant something else in this particular situation. A certificate is a certificate by any other name, and if the legislature of this state wanted it to be something else, they would have clearly and unambiguously said that, and that's why the court below got this right. Although I don't think it's necessary to address because the statute's pretty clear, the certificate involved here does confer a right. It does confer something that Karvo does not have the ability to do, and it depends. ODOT wants to draw the line back to, well, you can submit a bid, it just won't, it'll be rejected. The right conferred is the right to do work for the state of Ohio Department of Transportation. There's no way around that right. The fact that we can do work for other people, while pragmatically is impossible, because once you get the scarlet letter, once you get debarred, once you have your certificate revoked, you are not going to get work in any other jurisdiction, which is what makes this case so important and why ODOT wants to avoid it. The right to bid work for the Ohio Department of Transportation is the sine qua non, is having the certificate of qualifications to do the work. You cannot divorce the concept of a certificate of qualifications from the debarment process. It's one and the same. It's written right there in Ohio Revised Code 5525.03. And in that regard, I would point out that in the very second sentence of the statute, it says that an applicant shall apply. It is mandatory on a person that wants to bid to shall apply for the certificate of qualification. This is not something that simply restricts ODOT. It is something that's mandatory and compulsory upon the person that wants to bid for the work for the Ohio Department of Transportation. And the failure to get that certificate of qualification denies the right and ability to perform work for the Ohio Department of Transportation, which is absolutely a right, even if we want to go there, even though the Ohio legislature didn't do so, to do work for the state of Ohio. A word about the Ohio Department of Transportation not putting the wrong court into its order. I think we fully and fairly addressed that, but the Hughes argument was not made below, and the courts and the cases that are relied upon are the cases where it's the person, the appellant, that's suffering the harm that's caused by the order that's claiming, I didn't get due process, I didn't get this right. Nobody's claiming here that we didn't get the notice. The parade of horribles about the argument that we just heard, I don't need to go on and on about them. A bulletproof way to protect anything that happens to you is to put the wrong county jurisdiction in and just see there and see what happens. And when you lose, say I put the wrong county in there, procedurally, ODOT complied with everything that needed to be in that order. Whether it got it right or wrong is a different issue. Just like it got the substance of its order wrong, it got the venue of the court where the appeal should be taken as wrong. Your Honors, we believe that it's pretty clear. I do not want to sit up here and be redundant of myself. I'm pleased to answer any questions that you have. I respectfully suggest that the concerns that the department is raising with the statute are with the statute and not with the decision below. It is not for this court, respectfully, for it to rewrite what the Ohio legislature has put into a statute, but for the department to urge the representatives of the state to change if they so wish. So with that, unless there are any questions, I would respectfully urge the court to affirm the decision of the court below.
Okay,
Thank you.
very much. Council, you have 2 minutes and 17 seconds.
Thank you, Judge Callahan. Your Honors, 11912, as Mr. Sheets indicates, applies to licenses. If a certificate does not meet a license, then 11912A1 does not apply, and 11912B does, because the adjudication at that point is an other adjudication. It's not the denial, revocation, or suspension of a license. And again, generally the cases that have, just so I put things in perspective, generally these cases go to the sanction. Oh, it's not quite a revocation, it's not quite a debarment. We admit this was a revocation, really operated more like a suspension because of the limited duration. But it's not but whether it's a revocation or suspension doesn't matter for 119 purposes. But if it's not a license, then it doesn't apply, then it doesn't go to 11912A1, which is the home county, which would be Summit County. It's an other adjudication, which means Franklin County has jurisdiction. Karvo agrees, and Mr. Sheets commented that, hey, the language is clear. He didn't attempt to defend, though, cases where just because something's called a certificate or has that label, I gave you a couple examples, that automatically qualifies as a license, despite the straightforward language of 119.01B. But even statutes that are seemingly unambiguous, courts should not attribute unreasonable, untenable interpretations. There's always that limit. Courts should not construe statutes to achieve absurd results. And to say that anything with the word certificate is automatically a license by that without any consideration of what it does is not a reasonable application of that statute. If the right is, as Mr. Chief says, is to do work for ODOT, Karvo can still do subcontract work for ODOT. They don't need a certificate of qualification to do that. There are exceptions. There are environmental remediator contracts. There are specialty contracts from work.
Council,
Yes.
that your time is up.
All right. For this reason, we would ask you to vacate the decision below. Thank you very much.
Thank you. All right, thank you both for your presentations. This court will take the matter under advisement. We'll issue a written decision, which will be mailed to both sides. It will also be posted on our website and that of the Ohio Supreme Court. That concludes today's oral argument.